All right, chapter 12. This chapter is about leases, landlords, and tenants, and all kinds of rental issues. We're going to go over leasehold estates. When it pertained to ownership, we went over estates and land. That was like chapter 6 or 7, 6, I think. And then this chapter, we're going to go over the leasehold estates, which are less than freehold. We're going to go over then types of leases as well. And we're going to go over a lot of good stuff here. So, in this chapter, we're going to explain the characteristics of the four leasehold estates. We're going to describe standard lease provisions, including various forms of eviction and the effects of the Truth in Renting Act and the Americans with Disabilities Act. We're going to go over, we're going to discuss differences between various types of leases and finally identify the functions of a property manager. So let's start off with the term lease. What is a lease? Well, first of all, it's an intangible asset that is considered personal property. I mean, you could touch the paper that a lease is printed on, but you can't touch what it represents, and that is your rights. So a lease is where an owner, it's a document where an owner, who is the lessor, intentionally transfers most of their rights, like the right of possession of their premises, to a tenant, um, who is the lessee, for a limited period of time as defined in the lease. The lease also sets forth all the length of the lease, the all the obligations, in the contract, the amount that's to be paid for rent, when it's to be paid, what exactly is being rented, and the uses of the property, all of that. So the lease sets forth the length of the contract, the amount to be paid for the right to use someone else's property, and it defines all the rights and obligations of the parties. So a lease is where an owner actually conveys to a tenant their physical property, and they transfer all of their rights to the tenant for a limited period of time as defined in the lease, except for the right to sell the property, of course. So a every lease has a demising clause in it that says that the landlord is to let the premises and the tenant is to take possession of the premises. So demise is a transfer of property by lease. Every lease has a demising clause describing what the landlord is renting and what the tenant is taking possession of. And lease is both a contract and a conveyance in that regard. So that is a lease. All right, so let's highlight page 227. That's this, and page 228. We'll highlight once again something we went over in the previous chapter, that according to the statute of frauds, leases only need to be in writing if they're 3 or more years. However, when a real estate agent's involved, it always needs to be in writing. Leases can be recorded and added to the public record if they're 2 or more years. So transfer of property by lease is known as demise, not to be confused with devise. What is devise? Devise is a transfer of
Transfer of
property
property in a will.
in a will.
In
There you go. Correct. Just let me know when you guys have all the highlights, and then I move on to the next page. You know the deal. Don't make me ask every time. It makes it go by a lot quicker. Just say, got it.
Got it.
Everybody got it?
Yes.
Okay.
Got it.
So the statute of frauds, you guys seen this slide before in the previous chapter too, states that all contracts for the sale of real estate in New Jersey are required by law to be in writing. So they must be in writing. But leases, they only need to be in writing if they're 3 or more years. But if a real estate licensee is involved, it got to be in writing, doesn't matter the length. And leases can be recorded if they're 2 or more years. And why is this? Because it's extremely risky to rely on oral agreements or contracts for leases. They should always be in writing, but they're not required to be if the lease is less than 3 years, unless a real estate agent is involved, of course. Because any contracts we do must be in writing. Remember, we also follow real estate laws of the state, 4515, the New Jersey statutes, as well as the administrative code, 11.5, Title 11, Chapter 5. That states that we always have to have contracts for sale or lease in writing. Licensees must never have verbal contracts. An estate in land describes the amount and kind of interest that someone has in real property. Same definition we learned in Chapter 6. Now, there are 2 categories of estates and land. Freehold is the category of ownership, and we went over those 3 types of freehold estates back in Chapter 6. Does anybody recall what they are? What is the most complete form of ownership recognized by law? It's ownership forever without restrictions.
Fee simple.
Okay, now that goes by 3 names, correct. It goes by 3 names though, fee simple, or fee simple absolute. Okay, now what's the next type of estate that's a freehold estate? It's ownership forever, but it's based on a restriction.
Fee determinable.
Fee determinable, but it also goes by defeasible
Restriction.
fee or conditional fee estate. Correct. And what is the final type of ownership category of freehold estates?
Life estate.
A life estate. Correct. And let me dare throw out one more. What do we call a life estate that's not based on the life of the person it's given to, but based on someone else's life? It's a Latin term.
Porotruvi.
There you go. Por otra vie. Very good. Very good. A life estate por otra vie. All right. So in this chapter, we're going to go over the 4 types of leasehold estates, which are less than freehold. It is not the category of ownership. So, and it's where an owner intentionally transfers some of or most of their rights, except for the right to sell the property, and the interest in the real estate they own to a tenant for a limited period of time as defined in a lease. So a lease is considered personal property that's an intangible or incorporeal asset. So remember I told you that you can't take away someone's rights once it's been established that they have them? Well, a leasehold estates, those tenants are given those rights based on the terms of the lease. And as long as they don't violate those rights, as long as they don't violate the terms of the lease that granted them those rights cannot be revoked. But if they violate the terms of the lease, they can be revoked, but only by a judge. And that's through the process known as eviction. That's what eviction essentially is. So we'll get to that in a moment. But there are 4 types of leasehold estates: estate for years, periodic estate, also known as period to period, an estate or tenancy at will, or an estate or tenancy at sufferance. Rent is due at specific intervals per the lease. If it's not directly stated in the lease itself, New Jersey law says that rent is due in the arrears. That means after the end of the term for which the tenant occupied the premises. At the end of the month, the opposite of an advance at the beginning. And anyone who terminates a lease early is in breach of contract. A holdover tenant is what we call a tenant who did not vacate the premises after their lease term rights had expired. Now, a holdover tenant is not necessarily a negative thing. The landlord could choose to accept that holdover tenancy if the tenant continues to pay the rent, but they should require them to sign a new lease. Eviction is the legal process of removing a tenant through the court system. A landlord cannot lock out a tenant or turn off their services or physically remove them. The tenant does have rights. Eviction is the process of revoking those rights because the tenant violated the terms they agreed to in the lease, which granted them those rights, or their lease rights have or the lease expired granting those rights. There you go. So these are my explanations. I'm throwing them here now. I know they're not right here in the book just yet, but these are important things that should be discussed earlier on since we're going to be going over them. So that's why I gave these explanations in this order here in this slide. These are my explanations and my definitions of these things. They may vary slightly from what the book says because mine is clearer. Okay, so let's go over the 4 types of leasehold estates. Estate for years, periodic, tenancy at will, tenancy at sufferance. So just highlight and write the number 4 there. There's 4 leasehold estates, and then just highlight the numbers here. Those are those 4 types of leasehold estates. That's on page 228. And now on page 228, we could go over these. Here's a basic rundown of them, and then we're going to go over what the book has, and we'll do the highlighting and all that stuff. So what is an estate for years? This is just my quick rundown of them. So an estate for years is a lease for a definite period of time for a fixed term. It has a start date and it has an end date. You know when it ends. So therefore, there's no notice that a landlord needs to give a tenant to get out. If you didn't renew the lease, you got to be out when it expires. You know when it expires, there's an expiration date in the lease. The periodic estate, or period to period, is a type of lease that has a date in it, but instead of being an end date, it is a renewal date. That lease will automatically renew for the same amount of time the original lease was for. 1 month lease will renew for another month to month. Or it could be 3 months, will renew for another 3 months. 6 months will renew for another 6 months. 1 year automatically renews for another year. 2 years automatically renews for another 2 years. We'll go over how much notice needs to be given by a tenant when they do not wish to renew these types of estates, but that'll be a little bit later. It's coming up. And then we have an estate or tenancy at will. This type of estate is for an indefinite period of time. It is undefined how long the lease period term is. You could stay there at the landlord's will. Either party must give 3 months notice to quit when they want to terminate this type of leasehold estate. And then lastly, we have an estate or tenancy at sufferance. This is a type of leasehold without the landlord's consent. So basically your lease expired. This is when a tenant had a valid lease. This is not for squatters. This is when somebody had a valid lease, the lease expired, they didn't renew it, and they're not paying rent. So every month that the tenant remains, the landlord is suffering. So that's why they call it a tenancy at sufferance. So what are those 4 types of leasehold estates, and what are their distinguishing characteristics? On page 228, let's highlight distinguishing characteristics of a leasehold estate. Let's write of leasehold estate there. Let's do the highlight first and then write over the highlight. This way you don't smudge your ink. And then An estate for years is for a definite period of time. I wrote right next to that, for a fixed term with an end date. And periodic estate automatically renews. Right there, it has a renewal date in it. That's its distinguishing characteristic. Estate at will, it's for an indefinite period of time. Underline the word indefinite because I want you to associate the word indefinite with an estate at will, so that you could associate them, because often they'll tie that word into an estate at will with the exam questions. Let me know when you're done writing that.
Done.
Got it.
Okay? Everybody good?
Yeah.
Yes.
Good.
All right, so an estate at years, an estate for years. Don't let the name fool you. It's for a fixed term with an end date. But it doesn't need to be for a period of years. Don't let the name fool you in that regard. An estate for years need not be for years. It could be for a week. It could be for 3 months. It could be for a year. It could be for 2 years. It has an end date in it. You know when it ends. That's its distinguishing characteristic. As we've seen on the previous slide right here, it's for a fixed term with an end date. It doesn't have to be for a period of years. It has a specific period of time with an end date in it. No notice to quit is required at the end of the lease because it has an expiration date. If the tenant doesn't renew by signing a new lease, they must vacate. Ouch! So let's do the highlights there for estate for years.
I can see anything.
Yeah, I don't know what the heck just happened there. Hold on. Let me put you back on screen there. There you go. Sorry about that. Zoom had a brain fart, I guess.
Got it.
Got it.
Okay. A periodic estate is from period to period. It's a lease with a renewal date in it rather than an expiration date. The lease will automatically renew for the same amount of time that the original lease was written for, unless either party gives notice to quit. That means to terminate before the lease renews. How much notice required would depend on the term of the lease, the length of the lease. So, a week to week, 1 week's notice; month to month, 1 month's notice. If it's a period of years, 3 months' notice is required. And when a tenant gives notice to quit, but then doesn't vacate, they can be held liable for double the rent for each month they held over. Because the landlord would have to cover those carrying costs because they'd be in breach of contract with the next tenant who they may have a contract with that's supposed to be moving in. So that makes only sense that they should be able to do that. So let's do the highlights on that. And I want you to also cross out the word indefinite because even though it makes sense here, I just don't want you associating the word indefinite at all with periodic estate. So let's just cross out the word indefinite. Indefinite, I want you associating that with a tenancy at will.
Done.
Anybody else still working on it?
Got it.
I am. I'll take a picture of
Okay, no. Take your time. Finish off your your highlights there.
I got it.
Okay. So, an estate at will or tenancy at will, do those highlights while I explain. Is
Victor,
it?
can I take a photo of the last screen? I'm sorry.
Sure.
Go ahead. You can go.
So an estate or tenancy at will is for an indefinite period of time, meaning there's no length of time specified in the lease for the term. Either party must give 3 months notice to terminate this type of lease. It's terminated automatically on the death of either the landlord or the tenant. And both parties must agree to the indefinite term with that 3-month notice to quit. An example where this would be used is where a landlord's notified their property is going to be taken by eminent domain. They don't know how long they could actually lease it out for because they've been notified the state's going to take it away, but they don't know when exactly that's going to occur. So in the meantime, you got a mortgage payment you got to make. You got to pay taxes on that property. So the landlord could lease it out, but they don't know how long to lease it out for. And by eminent domain rules, they have to turn the property over vacant. So they can lease it out to a tenant. And as long as the tenant's aware that when the landlord notifies you that the state told them that they're going to be taking it and you got to get out, they're going to let you know when it gets closer to that time. Well, then you'll have at least 3 months notice to find another place and get out. So as long as you're cool with that, you could rent from that landlord. So that's the tenancy at will. It has to have that 3-month notice to quit there. Just let me know whenever you guys got that.
I'm done.
I'm good. I got it.
Okay. Estate at sufferance or tenancy at sufferance is when a tenant once had a valid lease. The lease expired, they didn't renew it, and they didn't move out. They're now considered a holdover tenant. And they're not paying rent, making it even worse. So a holdover tenant not paying rent can be evicted at any time. That's the only reason really where a tenant can be evicted at any time without the landlord having to provide a written notice to quit their lease breaking activities in advance before starting the eviction process. Now, this is not squatters' rights, which could create an easement by prescription. This is a tenant who once had a lawful lease, but they never renewed it or moved out. So just as fee simple absolute is the highest estate in land, tenancy at sufferance is the lowest. That tenant doesn't have any rights there. Their rights expired. They didn't move out and they're not paying rent. So they could be evicted at any time. However, the landlord can't remove the tenant themselves. The tenants still have rights, and those rights can only be revoked by the court once you prove to the court that the tenant is violating the terms of their lease, or the lease expired and they didn't move. So the tenant's rights expired, they didn't move out, they're not paying rent. Every month they remain, they cause the landlord to suffer. Thus, the tenancy at sufferance. It's important you write that up here. You're doing your highlights. Make sure you also write also not paying rent, because they didn't put that here in the book. But that's a pretty important that's a pretty important element right there. They're not paying rent either. Okay.
Yes.
Okay. So to recap, demise is a transfer of property by lease. A leasehold estate is a tenant's rights to occupy someone else's land and are considered personal property, which is an intangible asset. A holdover tenant is a tenant whose rights to occupy real estate expired, but they did not vacate at the end of the lease term. And there's 4 types of leasehold estates. Once again, we have estate for years, which need not be for a period of years. Its distinguishing characteristic is that it has an end date in it, so no notice to terminate is needed. No notice to quit. A periodic estate is from period to period that automatically renews for similar succeeding periods of time. The notice to quit varies depending on the length of the term. Week to week, 1 week's notice. Month to month, 1 month's notice. A period of years, 3 months' notice to quit is required before the lease renewed. A tenancy at will is for an indefinite period of time. No termination date in it. It's created with the consent of the landlord or by a court order, and can be terminated by the death of either the landlord or the tenant. And it does require 3-month notice to quit by either party. A tenancy at sufferance is one where a tenant lawfully came into possession. They remain in the property without the consent of the owner after their rights expired and isn't paying rent. So a holdover tenant not paying rent can be evicted at any time without needing a notice to quit. When you don't pay rent, The law doesn't require any advance notice be provided by the landlord. All right. So here are some of the standard provisions, the essential elements of a valid lease. Same thing as pretty much the essential elements of any valid contract. You have to have a demising clause. Well, you have to be competent parties, sane, sober adults that are adults, right? A demising clause, landlord is to let and a lessee to take possession. You have to have a description of the premises of what exactly is being rented and what is excluded from the tenant's use. Terms must be clearly stated, the duration or at will. How and when the rent must be paid has to be specified. If you don't specify, New Jersey law says rent is due in the arrears, the opposite of an advance. The lease must be in writing if for a term of more than 3 years, and it can be recorded if more than 2. If licensees are involved, it always needs to be in writing. And of course, like any contract, it needs to be signed by all parties. A lease that's only signed by the tenant is not valid. It's not legally enforceable. It needs to be signed by the landlord as well. So if the landlord gives you a copy of the lease, but it's only signed by you, you got to insist on getting that copy that they signed too. All right, window guards. Window guards are important. Here's a screenshot of it from the lease contract, section 36 within our leases. Unfortunately, nowhere in the book is there a paragraph talking about window guards, explaining what they are, who needs to be given them, or when they need to be installed. So let's go over those window guards, shall we? This is section 36. So on page 235, I would put a highlighted box around section 36 in the book. Section 36 of the lease on page 235. Go to page 235. That's one of the pages of the lease that are in this book. Put a highlighted box around section 36. You have that?
Yes.
Okay. So I have this slide for you. You may want to snap a picture of it. It makes it a lot more, it explains it visibly more appealing and in more detail. The part that's within the box is the part that you need to study for exam, though. Window guards prevent the window from opening wide enough that a child could fall out. It applies to buildings with 2 or less rental units. Window guards must be installed by the landlord. They must be installed by the landlord. If a child 10 years of age or younger will be living there or regularly present. If the tenant gives the landlord a written request to install them. Now, homeowners associations, HOAs, they're responsible for installing window guards in hallways and common areas. But they're only required on first floor units if the windowsill is at least 6 feet above grade. That means it's 6 feet above the ground, because a child could fall out and hurt themselves. It's not required, really, on higher levels. Usually people have fire escapes and things of that nature. Yeah. Now, buildings with 3 or more units, it's a little bit different. I gathered this information for you just for your own edification. Landlords must install window guards unless the tenants indicate in writing that they do not want them. And every year they need to do this before February 15th. They must have the tenant fill out a form about window guards, that they don't want them. Otherwise, the landlord is required to install them. Now, if they are installed, window guards must be inspected twice a year, once between March 1st and May 1st, and between September 1st and December 1st. And they need to keep a log recording of the results of their inspections of those window guards. Now, if you have window air conditioning units, those air conditioning units must be installed using tamper-resistant one-way screws to bolt that air conditioning unit securely into the window frame without leaving any open space greater than 4.5 inches. Residents may be charged up to $20 for each window guard installed. But this is the part you need to know for exams, the top part in that box, okay? All right, so here's some pictures. This is what a window guard looks like from the exterior of a building. Here's what it looks like from the inside. Or if you have those windows that swing out, it's just an L bracket that doesn't allow the window to open greater than 4.5 inches where a child can slip through. So here's a window guard installation. There's no gap greater than 4.5 inches. Even if the window can open further than the window guard's size, they need to put these L-shaped bracket stops to prevent that window from opening any further using one-way screws. All right, let's look at the typical provisions in leases. Well, they discuss the use of the premises, the term of the lease, the start and end date or renewal date, or if it's at will. New Jersey requires agency relationships be disclosed in leases, and they do. Section 39 of the lease does disclose that. So let me open up a lease. I'm not going to use the link from the Google Drive. I'm going to open up a lease on my computer so that you can see it full screen. It's easier to show it to you that way. Just got to find it. Hold on. Oh, here we go. Residential lease. So just like a sales contract, you have the table of contents talking about the different parts of a lease. Section 36 relates to window guards. You see that? And we just discussed that you got to disclose agency relationships. So here's a disclosure that the CIS form was given, and then beneath that, Section 39, Declaration of Licensee Business Relationships. An acknowledgement that the tenant received a copy of the Truth in Renting Act, which we didn't go over yet. There's a lot of stuff in there. So an acknowledgement that the CIS, the Consumer Information Statement's been provided, has to be in the lease, and we could see that. Acknowledgement of, where is it? The Consumer Information Statement, Section 38. If we were to scroll down in the lease to section 38, by signing this lease, the landlord and tenant acknowledge that they received the CIS on real estate business relationships, because we're not required to have them sign it. We're just required to discuss it with them. So the way you approve it, there is a signature line on that CIS, but you could also you also have it here in the lease contract that acknowledges, by signing the lease, you're acknowledging that you got your copy of that CIS as well. To cover our butts. The Opinion 26 notice must be the cover page of any contract prepared by licensees. That includes leases. Even though most people don't use attorneys or hire attorneys for leases, I've had some that did, but we need to inform them of their rights if they're not using, especially if they're not using an attorney. We have to inform them. That's the whole purpose of the Opinion 26 notice, to inform people that they have the right to hire an attorney, even though most people don't use attorneys for leases. And you could see that, because if we go to the lease itself, as well, maybe it's not here, but we would have to, the system doesn't automatically print it out as the cover page like it does with the purchase contract, which is strange, but it should be. If not, you need to manually print it out and make sure that Opinion 26 notice is sitting on top of this page as the cover page. So before people see the actual lease, they see the Opinion 26 notice. And what is the Opinion 26 notice? It informs people they have a right to hire an attorney. You cannot deprive them of their rights. You must inform them that they have the right to hire a lawyer. And then we have the federal lead-based paint disclosure. It says that residential leases for property built prior to 1978, we need to give them that disclosure statement, the pamphlet, and a 10-day opportunity to inspect for lead hazards, or waive that opportunity altogether. I got all these people keep popping in and out. They got a problem with the Zoom or something?
That's me, Victor. My laptop died,
No.
so I had to connect on my phone
Okay.
and then come back on my laptop.
All right. So New Jersey also has that lead safe law that says that it requires inspections of rental units. So, we have that federal lead paint disclosure for properties built prior to 1978. You have to use this on sales contracts, but also on rentals. But we also have this New Jersey law that now requires inspection. So the federal law just says that any property built prior to 1978, you got to give renters the pamphlet to protect your family from lead in the home. Remember what that pamphlet looks like? This is the cover page. It looks like this. That's the pamphlet. It informs them of the dangers and hazards of lead and what to do about it, what kind of resources are available, how to remediate it, etc. And then we got the lead disclosure statement that needs to first be filled out by the owner and then by the tenant. And then we have a 10-day opportunity to give that tenant the right to conduct an inspection or waive that opportunity if they wish to close any sooner. So let's see, where's that lead disclosure here? Section 35 in the lease. So let's scroll down section 35. Section 35 right here. And continues down to here. All right. So the tenant acknowledges receipt of the EPA pamphlet, Protect Your Family from Lead in a Home, and a copy of the document, Disclosure of Information on Lead Paint and Other Lead Hazards, and it's signed by everybody. And the New Jersey Lead-Based Paint Inspection Law acknowledgement, that's New Jersey specific law. So this was added as a second part to our contracts. The landlord acknowledges that effective July 22, 2022, all rental dwelling units built before 1978 required inspection pursuant to New Jersey lead-based paint inspection law must be inspected for lead paint by July 22nd, 2024, or upon tenant turnover, whichever is earlier. Note, there are several exemptions, including but not limited to seasonal rentals that are rented for less than 6 months duration each year by tenants that do not have consecutive lease renewals. The law imposes an obligation on municipalities to perform or hire or allow landlords to directly hire a certain lead evaluation contractor to perform the inspections of single-family, two-family, or multiple rental dwellings that are covered by the law for lead-based paint hazards. At times specified in the law, the type of inspection depths on the lead levels in children in the municipality where the rental dwelling unit is located, landlords must provide evidence of a valid lead-safe certification to new tenants of the property at the time of tenant turnover, and unless not required to have had an inspection, and shall attach a copy of such certification to this lease, which tenant acknowledges that the landlord has attached. So the federal law requires disclosure of any known lead hazard or inspections. The New Jersey law requires inspection. So, and that's this section that we highlight on page 152 on chapter 9 we went over. That's where this screenshot comes from. I don't think there's another screenshot in this chapter about it. Yeah, this chapter only speaks of the federal lead disclosure requirement. Okay, security deposits, page 239. Anybody know what security deposits are for?
It's to, I guess, hang on to in case there are any damages or anything at the end of the term. It can be deducted from the fees or that may be
Okay,
charged.
it's for damages, yeah. And but the landlord has to allow for wear and tear by ordinary occasional use. You know, so like if the carpet's worn out by the front door, that's expected. You know, ordinary wear and tear, you go in and out of that area the most, right? But if there's a big grape juice stain in the center of the carpet, well, that's not ordinary wear and tear. That's damages, right? So, yeah, so it's for damages that the tenant may do. Do you know what the maximum amount they're allowed to charge by law for residential property?
No.
1.5 a rent?
It's
The
1.5 times the monthly rental figure. Now, in commercial real estate, they have no maximum amount that is secured by law. It's however much the landlord can get away with asking the tenant to pay. So security deposit is a guarantee of rental payments for damages. The money must be placed in a special interest-bearing account used solely for security deposits because the landlord's holding on to it for the entire term of the lease. And that money could have been in the tenant's own savings account earning money. So the landlords or property management company of real estate licensees, the broker has to have a special account. Either the landlord or their property management company has to have a special bank account used only for keeping tenant security deposits in, and it must be interest bearing because the tenants must be notified where that money's being held, how much interest they're earning, and the landlord has to be paying the tenant that interest that's earned on their money on the anniversary of their lease. They either cut them a check for that interest earned or they deduct it from their rent so the tenant pays a lesser amount on the anniversary of their lease. Either way, they need to get that money that is due them because it's their money. The landlord doesn't get to keep that interest. So the penalty for the landlord that does not pay the tenant that interest on their security deposit could be double the entire security deposit that they were holding. So the maximum security deposit allowed by law in New Jersey is 1.5 times the monthly rental figure. There is no maximum security deposit for commercial real estate. Pet security can be charged as long as it doesn't exceed that 1.5 times the monthly rental figure. It's still security. Doesn't matter how you label it, it is still security. And I would not call it pet security. I would just charge the tenant the security deposit. Because what if it's a service animal and they do damage? Well, you can't be charging additional security or additional charges for service animals. So just call it security. Don't call it pet security. And there's your way around that. Service animals cannot be charged additional fees, rent, or security because they're not pets. So it's not advised to call it pet security. They must be returned within 30 days of the lease termination, any security deposits. And if there are no damages, the penalty for violating this rule is double the entire security deposit. Deductions for damages must be on an itemized report. The landlord can't just say, you ain't getting your security deposit back because you messed up my place. They have to give you an itemized list of how much it costs for this damage to get repaired and how much it costs for this damage to get repaired. They got to give you an itemized list to repair all those damages or clean up the garbage or mess that you left behind. And yes, smoking or smells and cleanup from smokers is one reason. Especially you've been smoking weed now that it's legal. If that stinks up the apartment, to get that stink out, they could charge you a fee to do that. Same thing as if people cook spicy foods that have smells that get into the walls and the carpet, into the cabinetry. It could require more scrubbing down to get rid of certain odors, You get people that like to cook spicy foods. Those odors get into the thing. A landlord can charge you, would take that out of your security deposit, so that they could clean it down and scrub it down, so that the next tenant gets a nice, clean, fresh apartment. Deductions for damages must be on an itemized report. If the property is sold, the landlord must turn over security deposits to new owners and notify them where it's being held. Because they're going to have to give it to the new tenants when they move out. 1.5 times monthly rent as the maximum security allowed by law. And if your rent ever raises, they're allowed to raise that security deposit, or they're allowed to raise that security deposit as well in line with that, as long as it generally doesn't exceed 10% of the total security deposit. Is that enough? 1.5 times the monthly rental figure? It should be for most people. But when you get bad tenants, yeah, 1.5 times may not be nowhere near what you need to fix the place up. Remember, I showed you guys some pictures of some bad tenants before. How they messed up an apartment that was just recently remodeled, and they're living in there. They were cutting out the plumbing and connecting the first floor electric to the second floor so they could steal the electric because they didn't pay their bill. And the same thing, they were rerouting the gas pipes so that they could get the heat and hot water. Freaking horrible. Then you got to get plumbers in there to come in and redo everything, put it back up to code, because they just made the place extremely dangerous. They could have blown up the house by doing that. Or you get these tenants that they're just very vindictive. I've had apartments that I went to rent, and I go into the apartment and there's a horrible stench in the apartment. And the longer that the tenant is gone, that stench gets worse and worse. And you know, I seen the tenants do this. I was a superintendent of an apartment building myself, and I've seen this happen too. Where a tenant, you know how the closets, you know how your bedroom closet is, and how sometimes there's a shelf in the closet. Well, you know how you got to get a step stool to get up to see the back of the shelf on that closet? Maybe climb up on a chair. Well, I've seen where tenants would put holes in the wall at the back of the top shelf in the closet, and then they would proceed to drop dead fish into behind the walls. So the fish starts to rot and gets a nasty smell there. You get the maggots and all that, the nasty smell. They intentionally do this. There
Wait,
are,
what was the purpose of it?
huh?
What was the purpose? What did they do?
They're
What
na-
they,
they're scumbags. Okay, to put it plainly, but it's a bad tenant. Sometimes you get these people who are just awful people. Maybe they're trying to get retribution against their tenant because they evicted them because they didn't pay rent. So they want to get even. Pay your damn rent, for crying out loud. You know, listen, some people are just horrible people. This is some things that they do. I've seen stuff like this. I've had it done where we had to rip apart the walls to get that crap out. You know, so the security deposit wasn't enough. They had to try to sue that tenant, track them down and sue them. You know, it's tough. You know, you get tenants like that. That 1.5 times the monthly rental figure may not be enough. Yeah, tenants do some awful stuff. You know, I mean, look, I not to disparage Section 8 tenants, but Section 8 tenants often get a bad rap because of the bad apples, who may also be collecting Section 8 benefits for housing. Most of the people collecting Section 8 benefits, they're good people. They just don't make enough money. They need that extra lift up to help them pay their rent to get by, to have a decent place to live. But you have some people that are just scumbags that are collecting Section 8 benefits. And those people give a bad rap because everybody is automatically assuming, because you hear all these cases of the bad Section 8 tenants, which are absolutely horrible nightmare stories. And they put that, they give a bad impression of all Section 8 tenants now. So sometimes landlords or potential landlords are like, oh, I don't want any of them Section 8 people. Those people, they're all like drug addicts and prostitutes and horrible tenants, because those nightmare stories that you hear about where they are. And they're so horrible that they get that impression that everybody collecting these benefits are like that, and that's not true. But the horrible stories are pretty horrible. I've dealt with this before. I had if you're collecting Section 8 housing voucher benefits, you have to get permission from your housing officer if you wanted to move. Okay. And if you're moving out of county, well, your Section 8 benefits are only good for the county you live in. You have to apply for them in the next county too. So the I had this lady that walked into my office one time, and she was looking for a new place to rent, and then she told me, "Oh, I'm on Section 8," and I was like, "Okay." I got no problem helping out Section 8 tenants find new rentals. However, Section 8 does not pay for the realtor's commission. So I asked her, I said, do you have the fee? If the landlord's not paying it, do you have the fee to pay the commission for me? Because I don't work for free. I got no problem helping out Section 8 tenants, but I don't work for free. So if the landlord is not paying the commission, do you have the money to pay for it? Because if not, I'm not working with you. Okay. And I've had this lady, she was like, "Oh, no, I got it. That's not a problem. That's not a problem." And then, so I start, we get friendly, and I start talking to her about, the different rental units, and we start looking over places and such, and, finding her places to set up appointments. And she gets pretty comfortable with me pretty quickly. And then she goes, "Oh, check this out." She's like, "Oh yeah, I got the permission from my housing officer to move." And she's like, "Yeah, I'll show you how I got it." And I was like, "Huh?" And she's like, "Yeah, because you got to give them you got to get permission, and they could be pretty strict with that. You need a good reason to move." So, they didn't want to give me they didn't want to allow me to move, but I gave them a good reason. And she's like, "I just went down to the pet store, and you could buy a bunch of cockroaches. They serve as food for other animals. And we just released the cockroaches, me and another lady there that wanted to get relocated. We just released this box of cockroaches into the apartment building, but we reported that. And then the landlord then sent out a pest control company to come fix it up. So that wasn't enough. So then we went and we bought a bunch of mice, and we released the mice into the apartment building. And now we called News, what was it, News 12 or something like that. And she's pulling out this article also from a newspaper that she had folded up, carrying around with her in a little plastic bag to preserve it in her pocketbook. And she's like, "Look, we were on the news," and she got her picture on a newspaper, how we were able to get moved because this building is now infested with cockroaches and mice. And I'm thinking, wait a minute. You want me to move you in, to find you a nice building with a good landlord, and you're telling me that you had that previously, but you just wanted to move. And in order to do that, you got a bunch of cockroaches and mice and infested the building with them on purpose? Why would I introduce you to another good landlord so that you can mess with them like that? I told her, "Get the out of my office." I didn't work with her. I told her to get the hell out of my office, but I was cursing at her. I said, "Get the F out of my office." I was like, what a scumbag thing to do. It's like, you want me to put you with a good landlord, and then you're going to do something like this? Get the F out of here.
Can't the landlord sue them for that if they find out?
Yeah, but I mean, how are you going to find out? I mean, unless the lady pulls out that the newspaper article out of her pocketbook and admits it in court, how are you going to, admit it? I mean, I could tell that she said that to me, but it's hearsay now. It's tough. It's tough. But you get some people like this; they're just nightmares. That's why a lot of people in collecting Section 8 benefits get a bad rap, because those people like that are in the minority, but they do exist, and that's why people who do collect Section 8 benefits that legitimately are good people get a bad rap because of those folks. I had another guy, he was also another Section 8 recipient, that he wanted to look for a new place. So he came to me and I was like, okay, well, we could set up the appointments, and here's some places we looked up that would be good for him. I told him, but you got to get the permission first from your housing officer. Did you get that yet? And he's like, no. I was like, okay, well, you'll need to get that permission first from the housing officer before we can start looking for another place for you. And then he was like, oh, okay. He's like, can you do me a favor? Can I use your phone, or can you call 911 for me? I said, excuse me? He said, yeah, could you call 911? I was like, are you okay? Is there a problem? What's going on? And he's like, I just need to call for an ambulance. Now I'm starting to panic. I'm like, are you feeling okay? Sit down. Are you okay? Do you need a drink of water or something? What's going on? He's like, I just need to call an ambulance, and the ambulance will come pick me up. I live down towards the hospital, so they'll take me down that direction, and then I tell them that I'm feeling better when I'm closer to my house, and then they just let me out, and then I'll instead of paying for a cab. Have you guys ever heard of such scams like this? The things that people are willing to do like that? That's insane. So I told this guy, I said no. And then I was like, you know what? Here, go ahead, call 911. Call them. You get your ambulance ride, but don't call back. Don't come back. I don't want to work with somebody that does crap like this. And I don't know. Yeah, I could see why some landlords don't, get freaked out and don't want to rent to Section 8 people. But look, this is by far not the majority, but these are just examples of those people who are collecting the benefits that are those nightmare tenants. They are disasters.
But so me to rush you, but how you can deny them, getting so like you was like,
Oh,
because
go ahead. Try to report me. I'll explain what a scumbag you are. This guy's calling 911 so he could get a free hospital ride. I don't want to deal with people like that. The other lady, she's admitting how she bought cockroaches and mice to release in so she could get the permission to move. Go ahead, report me. I'll tell your housing officer what you did.
strengthening is hard.
Yeah, you know what? Just get the hell out of here. Well, I'm not discriminating. These people are legitimately scumbags. I don't care what your race or color or anything like that is. This has to deal with the character of these people. The one lady, she was black. The other one, he was a Hispanic guy. But I don't care about what race, color, religion, whatever. This is just you could be a white person and doing this. You're just the biggest scumbag. That's your character. Who the hell does shit like that? Pardon my French. Who does stuff like that? It's crazy. All right. Moving along. I just give you some examples, but you know what? Otherwise, I encourage landlords to accept Section 8 tenants because I'm like, listen, that's a guaranteed payment. The payment's coming directly from the government every month. You don't have to worry about them losing their job or something happening. Section 8's still going to be putting a direct deposit into your bank account, and it's going to be on time most of the time. But that's a guaranteed payment. Why would you turn it down? Unless you get somebody like this, I would say just interview the tenant to check out and see where they're at up here, But then again, these people they're probably savvy enough to know not to talk like that to an actual landlord and tell them how they got to move. Well, I don't know. That lady was nutty enough to tell me. I guess she thought I wouldn't care as long as I got my commission. But you know what? I got some morals here, and I like to look out for good people. So I just kicked her out of my office. I mean, get the hell out of here. That's crazy. All right. Anyway, I tell you, I could write a book on my experiences in real estate. I really could. I got chased by a deaf dog, showing properties, walking in on people having sex, doing all kinds of stuff like this. These tenants I had to deal with, tenants who were cutting and stealing the pipes out of the to sell the copper, and the landlord wouldn't believe it until it happened like 3 times, and then I got him to install PEX piping, and then it didn't happen anymore. I mean, I got all kinds of stories that I could write a little short book about for real estate experiences, I tell you. All right, what do we have here? Okay, so we went over everything on this slide already, but I got everything here in one neat spot. If anybody snapped a picture of that yet or wanted to, go ahead before I change it.
Got it. Thank you.
So let's highlight this now on security deposits on page 239. They show you for commercial leases, there's no maximum amount of security fixed by law. Commercial landlord can charge as much as they can get away with. Anybody here a renter? Or a landlord for that matter?
I've read.
I am. I know.
Okay.
I rent the house, but the landlord that we have, the person who's rented to us, she's pretty good.
Huh?
And so far it's been 3 years and she's there on time. I wish everybody was like her.
All right. Now, have you learned anything that you may not be doing that you should be doing now here?
Rented to the people that you're just talking about.
The-
Because
what-
we did it one time and she took all the appliances for the apartment that we have in Regency. And I don't know if the people didn't see people because there's a lot of people in there. There's always somebody. And then just destroyed the apartment. We had to do it again.
Yeah, they destroyed the apartment. Yeah, see,
Oof.
that's the thing. Here,
So after that, we
I
never.
gave a
think
couple
back.
examples of bad tenants, and that's why Section 8 recipients often get a bad rap.
Yes.
By
We don't
far,
rent to
though,
them.
by far, though, the majority of people collecting Section 8 are not like that. But is there a decent amount of those horrible people that are nightmare stories? Probably more than the average, but
Yes.
but that's why you got to interview them really and try to do your best to.
Yes, but you
a
had
lot
to
of
put it
times-
in court. You had to put lawyer. We took a lot of money, we invested a lot of money just to take them out of the apartment.
Yeah, sometimes you may even give them money to get the hell out just to avoid the problem.
We had to pay the first month of the rent just to move, get out of here. And
Yeah,
then
just
after
please
that,
get the hell out. I'll pay you. Yeah, I know. Sometimes
we
it
did
can
it.
be
And it was a court and it was everything. It was a nightmare. And after that, we learned that now we just very picky with that stuff.
Yeah. You got to interview people, but you still cannot legally turn people down because of their source of lawful income.
We use an
Uh,
office.
some
we
land-
charge.
Some landlords can get around this by simply charging more rent to everybody, because there are certain threshold amounts that Section 8 will only pay up to a certain amount for a studio, 1 bedroom, 2 bedroom,
Yes.
3 bedroom. And there's different amounts if heat and hot water is included or not. They would pay higher amounts. So if you're renting a place and the place is asking for higher rent than Section 8 is willing to pay for a 1, 2, 3, whatever bedroom, then your place won't be approved for Section 8 because of the amount that you're looking for. Okay.
Yes.
Because there's certain amounts that they charge, but that they'll pay. But
Yes.
But don't use that as a reason to discriminate. Hey, I'm going to raise my rent a little bit to this amount because it's just out of the grasp of the threshold. I've seen tenants who were collecting Section 8 that they would do this too, where Section 8 would only pay a certain amount, and you're asking for a higher rent than that amount. then the tenant says, hey, listen, I'll pay that out of my pocket on the side. You'll collect all the money from Section 8 and I'll pay the amount above that. What is it, an additional $100? I'll pay it out of my pocket. Okay. Do not do that because Section 8, in their contracts, they specifically state there is no separate agreements and the landlord is not allowed to collect any amounts from the tenant other than this that is stated in this contract. So basically, you would be breaking the law by accepting that amount, number one. And number two, the tenant is probably never going to pay you that amount after they move in. They'll be like, screw you. Good luck. What are you going to do? Who are you going to complain to? You signed a contract that's all you were going to get. They know the law. They know how to play the system. So when if you ever get a tenant that does ask that, don't think that the landlord can get extra money from that tenant. And hey, the majority of the rent's going to be paid by Section 8. I'll get the rest out of the tenant because they'll probably not pay you that amount ever. Okay. Now, once again, I'm telling you this just to show you some of my experiences and stories with the bad element that is collecting the Section 8 housing benefits. But by majority, most of the people collecting those benefits are good people. I've dealt with a lot of Section 8 people, and they're just needy people, and that's the purpose of that. It's just unfortunate you get a lot of riffraff that get under the radar and they collect the benefits, and they make it work. They ruin it for the bunch. They create that stigma. All right, everybody got this?
Yes.
All right.
Yes.
And so late payments can be charged to tenants, but check your local rent control laws ordinances if they have them. Not all municipalities have rent control, but those that do, you better check the rules. Some tenants may be given must be given a 5-day grace period free from any late fees or penalties. Those people are basically anybody who's collecting a payment from the government, because you cannot penalize a tenant because the government's payment came in late, so therefore that they are relying on. You can't charge them late fees or penalties because the government was late sending the payment that they relied on, like people receiving Social Security or old age railroad retirement pension, or any governmental or quasi-governmental pension or payment. So here's that reasoning there that I just explained. And always check local rent control laws before charging any late fees or penalties. There could be restrictions on how much and when you could charge. There may be a limit on those late fees or penalties that you could charge. Like, for example, sometimes in our rental lease contracts, you don't have to just say, hey, there's a $50 late fee if you pay the rent the rent after so many days after it's due. Well, you don't have to just leave it at that. You could say, well, there's a $50 late fee plus an additional amount for each and every day that the rent still goes unpaid. So basically, that amount starts compounding, to kind of light a fire under the tenant's butt to pay the rent, But that may not be allowed in municipalities that have rent control rules. But most landlords don't even know that they know that they need to give a 5-day grace period free of any late fees or penalties, but they don't even know why or to who. They just know they're required by law to give a 5-day grace period, so they give it to everybody. But they're not required to give that grace period to everybody, just people who are relying on payments from the government. So let's highlight that in the book on page 239 as well, under late payments. All right. Possession of leased premises. The tenant cannot take possession until the dates specified on the lease come about. You, as a licensee, should never give a tenant access or keys, even just to put a few of their belongings in until the lease comes about. Oh, I'm not moving in. I just want to put a couple of my things in there. Don't do that, because in the eyes of the law, they could put one piece of luggage in there or bag of clothing in there. Now they're legally considered to be in possession of the premises, and the landlord would need to evict them to get them out. And if you gave them access, early access like that, and they end up being a problem, you could have issues. Real estate commission is definitely going to come after you and give you sanctions on your license, fines and penalties. But you're also creating a headache for the landlord. We already went over this one. Remember this one where we went over this in chapter 4, where the landlord's employee entered the apartment, started rummaging through the guy's fiance's underwear drawer and playing with himself in the corner of the room. And so the question was asked, are landlords or their employees allowed to enter a tenant's apartment because they have the keys to it? The answer to that is no. They need to have a legal reason to. Either they need to have prior permission from the tenant to enter that apartment for like treating for pests control or things of that nature, and they got the permission to enter, or for emergencies like a gas leak or flooding or things of that nature. Otherwise, the landlord does not have permission just to enter a tenant's apartment at any given time. The tenant can file a complaint. Trespass complaint could be filed with the local police department for defiant trespass, and this is the code 2A39-6. Now, in this particular instance, this guy did go to the police department, and they said, well, anything they didn't break the law, so they were allowed to be in there. That's kind of partially true, but partially not true. Is it considered sexual harassment because the guy was masturbating in his fiance's underwear in his apartment? No, because it's not sexual harassment. Sexual harassment would be if he whipped it out in front of her, but it's disgusting. However, did he have the right to be in that apartment? In this thing, they didn't say anything about him having prior notice that they were going in there to do any kind of maintenance or anything, and there was definitely no emergency. So he was illegally in their apartment, just rummaging through their apartment. And the Truth in Renting booklet, this is a booklet that all landlords, well, not all landlords, this is a booklet that goes over the laws and rules that all landlords and tenants must abide by. But only landlords in buildings with 3 or more rentals are required to give it to tenants. So basically, if it's a 4-family house and the landlord lives in one of the units, there's still 3 rental units available. They have to give the Truth in Renting booklet to them. But if it's a 3-family house and the landlord lives in one of the units, there's only 2 units available for rent. So they're not required to give the Truth in Renting booklet to. These are also the same buildings that require a state inspection, the ones that are 3 or more rental units available. Okay. Now the book words it in a little bit backward way. The simpler way to say it is, if there's 3 or more units, rental units available, not counting the unit the landlord lives in. But instead, they say, I forget how they word it. The book always words these things backwards. But anyway, this Truth in Renting booklet this defines I have a copy of the Truth in Renting booklet in our shared Google Drive, but this gets updated annually. So you're better off using the link on the Department of Community Affairs, the DCA's website. It's available in both English and Spanish. And our standard leases, I think, even have it written in there somewhere about the Truth in Renting booklet. Can anybody see the Truth in Renting booklet or a reference to it here? They actually go over some of these specific things that are mentioned in the Truth in Renting booklet, but added to our leases now, I guess, because they're common things. But you guys see anything here about the Truth in Renting booklet?
No.
Oh, here we go. Acknowledgement of Truth in Renting, section 40. See that? So let's go down to section 40 of this lease. It's an acknowledgement of the truth in renting to all tenants with a rental term of at least 1 month living in a residence with more than 2 dwelling units or more than 3 if the landlord occupies one. More than 3. Living in residences with more than 2 dwelling units or more than 3 if the landlord occupies one. I understand more than 3 if the landlord occupies one. That would be 4 units or more. But with more than 2 dwelling units, I don't understand that part right there, because that's kind of contradictory. I guess you could be safe just giving it to everybody, but by signing below, the tenant acknowledges receipt of the booklet, The Truth in Renting, a guide to the rights and responsibilities of residential tenants and landlords. Oh, you know what? The older versions of this actually had a link here to the Truth in Renting booklet. You know what? I would add that link to all of my standard contracts then as a provision, since it doesn't have it here. It used to have the link to it right here on the DCA's website. That this way they can't say it was never given to them, because the DCA no longer prints this booklet, even though they publish it annually. You would have to print it out yourself or give the tenant a link to it. I wouldn't just give them a link to it though, because then they could say, oh, well, you know, I don't have internet connection or whatever, and then you'd be screwed, you know. So you'd have to print it out and give it to them as well. And not bad to also provide it in the lease too. Okay, so that Truth in Renting booklet is in the class links Word document in the shared Google Drive. But I'll also give you a copy of it right here, if I did not already previously give that to you in an earlier chapter, chapter 4, when we went over that. Here it is. Boom. Okay. And it goes over all kinds of issues. All right, legal principles of the lease, improvements. You know, tenants are not allowed to do improvements without the landlord's written permission. It goes over that in the Truth in Renting booklet too, but also in the leases. Our standard leases do. Right? Where is it here? Violation, tenants, repairs and maintenance, inspections, insurance, liability, waivers. There was something here about improvements, the tenants doing improvements. I don't know. No alterations or installation of equipment. Access to the property. A lot of these common things that are in the Truth in Renting booklet, we have as standard things in our leases now, though. Let's see. End of term. no assignment or subletting, violations of eviction and reentry. Here, let's go to section 12 and then we'll go to section 18. Section 12 talks about the eviction and reentry. Landlord reserves the right of reentry. This means that if the tenant violates the terms of the lease, the landlord may terminate this lease and regain possession of the property. This is done by a court proceeding known as eviction. Okay, so yeah, but they got to go through that. Okay, and then what's the other one? 18. It's a pretty big section. No alterations or installation of equipment. They can't install any improvements as carpeting, paneling, floor tiles, or any other improvement which is nailed or tacked down, cemented or glued in. Install any locks or chain guards, wallpaper, affix wall coverings, or other permanent types of decorations like paint. Install or change electrical, plumbing, heating, or air cooling systems. When painting, whether interior or exterior, the tenant must have the landlord's written permission regarding paint colors. All painting must be done in a professional and workmanlike manner. The tenant shall repair all walls and ceilings which had pictures or fixtures attached prior to vacating. So you got to fill the holes in the walls from any nails or anything. All right, so it goes over a lot of that stuff. You can't make any improvements or modifications without the landlord's permission. And approval of colors is a big deal. I'm telling you, that's kind of new that they have that actually in the contract here. But you know, it's good that it's now standard in there. As a former superintendent of an apartment building myself, I'll tell you, I had a tenant one time that she wanted to paint her apartment, and she was this big Hello Kitty fan. So she likes that Pepto-Bismol pink color. It's that bright pink color, something like this, you know, the very bright pink color. And that's a hard color to paint over. So the landlord allowed her to do it, paint her bedroom that color, provided that when she, at the end of the lease, she had to paint it back to a eggshell neutral color. Excuse me. And when she went to move out, she didn't want to be bothered with that. It was a pain in the butt to her to move everything. So she was like, oh, you could just do it. That's what she told me as the super. Oh, you could just do it. Just take it out of the security deposit. I was like, oh, okay. So I let the landlord know, and I submitted bills to the landlord for my painting, because that's not my normal duties to paint the apartment. So I got the paint, painted the apartment, you know, primed it, painted it. You look at the walls, the pink is bleeding through. Put another coat of primer, bleeding through still. Another coat of primer, still bleeding through. Let me try painting it again. Nope, still bleeding through. So I went and I spent a lot of money to get that Valspar type paint that one coat could cover anything, right? Nope, couldn't cover that. That $100 bottle, gallon of paint, or whatever the heck they charged for that, was expensive. Didn't cover it. So I went down to the paint supply place that we use, and I was like, what the hell, man? I was like, I can't cover this paint. It keeps bleeding through. I must have like 6 layers already of primers and paints and stuff on there. The guy started laughing. He's like, yeah, he's like, that could be difficult with some colors. He's like, there's a trick to that though. What you got to do is you got to get a dark color primer. We got this dark brown primer that you could prime the wall with, and then you could paint over it with a lighter color and it'll work. And so I ended up having to do 2 more coats with that dark primer and then a regular color. So I had, at the end of the day, I had like 10 coats of paint on this damn thing, and primer, or pretty close to it. So I had to paint all the labor to paint it over and over again, all the paint, everything. She was shocked when she didn't get any of her security deposit back. Well, should have painted it yourself. You know, that's what you agreed to. And I got all the bills to back it, you know, so Yeah, that was a problem for her. Whatever. Yeah, I don't want to do it. Wasn't a pleasure for me. All right, so the uh, improvements require written permission from the landlord. Also, sometimes you get tenants that they'll paint rooms black. Another one, there's the trick if you're a landlord. Get that dark colored primer. You got to go darker before you could go lighter. There you go. That's the trick. And then the trade fixtures. Trade indicates a business is a fixture used for business purposes. They're considered personal property. The tenant can remove it as long as they remove it before the lease expires. It's possible for a trade fixture, which is personal property, to become a fixture and part of the real estate if the tenant doesn't remove it before the lease expires. Some examples of that would be a barber's chair, the kind that are bolted down, gas station pumps, sinks in salons, beauty salons, shelvings in the supermarkets, the ranges and hoods in restaurants. You know, they're the tenant's property. They can remove it as long as they put return the property back to the condition that it originally was in. But they got to do that before the lease expires. You don't get to stay in there and do work on the property after the lease expires. The landlord should be able to get a new tenant in there by then. So anything that you left behind, that becomes the property of the landlord. Even copy machines. Oh my God, strip malls and office buildings. You know, landlords usually have tons of copy machines that were either leased or purchased by the businesses that were there. And often these copy machines, they're running $35,000 to $50,000 a pop. They're now the landlords. All right. Page 240. Where it says improvements. I want you to write trade fixtures above that, and then write tangible personal property / chattel, with and without an S there, chattels. It is customary to provide that such trade fixtures may be removed by the tenant before the lease expires. And then I just wrote down here, you don't need to, but it's possible for a trade fixture, which is personal property, to become a fixture, which is part of the real estate, if the tenant did not remove it before the lease expires. I think they even have that in here. The tenant may make improvements with the landlord's permission, but such alterations generally become the property of the landlord. That is, they become fixtures. However, a tenant that may be given the right to install trade or chattel fixtures, provided the tenant restores the premises to the same condition when they took possession. Okay. If they did not remove, you could add there that if they do not remove them before the lease expires, they become the property of the landlord. They become fixtures. Or they become part of the real estate, fixtures.
Got it.
All right. Everybody okay?
Got it.
Good? Everybody
Got
good?
it.
Okay, thank you.
Thanks.
All right, now maintenance leases carry an implied warranty of habitability, stating that the property is fit for human habitation and there's no condition present that could cause the threat to the health or safety of those who are living there or inhabiting the premises. So tenants must return that property in the same condition as received. The landlord's responsible for repairs unless specifically specified otherwise in the lease. Tenants are responsible for damages. The DCA, Department of Community Affairs, inspects buildings with 3 or more units, not counting the unit the owner lives in, at least once every 5 years. This state inspection, industry lingo, refers to it as a green card inspection. It's nothing to do with immigration. They just call it green card because it used to be on a piece of paper that was green when they give you that pass certificate. If rent is withheld by a tenant to force a landlord to make necessary repairs due to uninhabitable or dangerous conditions, it should be placed in an escrow account to pay the landlord later after they repair it, after repairs have been made. Because then they're going to have to pay back all of that back rent they've been withholding. You know, I want to go back for a second to, let's see, did I open up that link? I did not. Okay, let me go back for a second. I want to click on that Truth in Renting booklet, take a look at something in it. In this Truth in Renting booklet on the DCA's website, they go over a lot of issues. We were just talking about, what were we just talking about here? Okay, what I want to go over, I want to take a look to see if it says in the booklet who the booklet needs to be given to. Because in that lease now it says 2 units or more than 2 units. It says you got to give it to, in the lease it said to give it to people in more than 2 units, or if the landlord's living there, more than 3 units. Oh, wait. Yeah, that makes perfect sense. You see the weird wording that they had in the lease? Even though the book did the same thing. The lease does it too. Guys, remember the where it says the Truth in Renting booklet, the acknowledgement of the Truth in Renting statement, section 40? Who needs to be given a lease? It was a little bit weirdly written. The Truth in Renting statement needs to be given in residences with more than 2 dwelling units. What is more than 2? It is 3. Or more than 3 if the landlord occupies one. Okay, so there we go. There's the way of saying it's 3 or more rental units, not counting the unit the landlord lives in. Wow, do they make it confusing or what? So does the book. The book does the same thing. They use that same wording. Why don't they just say 3 or more units, not counting the unit the landlord lives in? More than 2 dwelling units or more than 3 if the landlord occupies one. What is more than 2? It is 3. How come they don't just say in residences with more than 3 units or 4 if the landlord lives in one, or 4 or more if the landlord lives in one? That's weirdly written the way that they have it there. Okay, sorry about that. I was just thinking back to that, and that was really bothering me, the way that it was written in the lease. Okay, so if rent is withheld, okay, sometimes tenants have a little bit of knowledge, stressing the little part, and they'll withhold the rent if the landlord is not making repairs. Now, keep in mind, this is not for like if the landlord won't paint the apartment. This is like if there are dangers, hazards, there's black mold, the roof is leaking, you know, there's serious damage issues. The heat's not working, you know. The tenant can withhold the rent until the landlord repairs the problem. But then once the landlord repairs the problem, some tenants think that they could just start paying rent from that day forward. Well, you got to pay back all that rent you've been withholding as well. That's the way the law is written. Otherwise, you could be kicked out because you still were occupying the residence, even if you were staying with a friend because it was too damn cold because the heat wasn't working. You still had your stuff there, so you're still occupying the residence. So let's do these highlights now. Do the highlights and make these notes here. That state inspection is often referred to as the green card inspection. That's the industry's lingo. That's how other real estate agents are going to refer to it as instead of the state inspection. They often refer to it as the green card. They'll just say, "Hey, is the property up to date on the green card?" That's what they mean. Don't look at them like they got three heads and you don't know what they're talking about. Okay. And then there's a section here that just talks about repairs. And then down here, we used to need to know this for exams. I don't think that you need to know it anymore. But where the landlord furnishes heat between October 1 and May 1, all rooms must be heated to at least 68 degrees from 6 a.m. to 11 p.m. or at least 65 degrees at night. That's where the landlord furnishes the heat where it may be included in the rent. That's the lowest they could have, whether or not you're not paying the rent. Okay, you guys do those highlights. I'm just going to run off to the bathroom really quick while you do that, okay? So, a state inspection, we often refer to that as the green card inspection because the card that they used to give you that certificate on when you passed the state inspection was green in color, okay? And then it has to be posted in the hallway somewhere. Now the state tries saving a lot of money and they allow you to print your own stuff. So you could print your own pass inspection certificate. They'll send you a PDF document by email and then you could print it out yourself. Now, these are required for this inspection is required for buildings with 3 or more rental units, not counting the unit the landlord lives in. Basically, those same buildings that require the landlords to give the truth in renting booklet to tenants. Those are the same ones that require the state inspection, not by local inspectors, but the state inspectors. So the DCA, Department of Community Affairs, performs the inspections on behalf of the state. State inspections must be performed at least once every 5 years for buildings with 3 or more units. Now, hotels and motels, they have to be inspected at least once every 3 years, and those inspections can be spot inspections without prior appointments or notification. But the 3 or more units with the residential properties, they need to be, there's going to be an appointment made for that. And it needs to be that green card needs to be updated every 5 years. So if you're selling a property that is 3 or more units, it needs to have that green card inspection, that state inspection, every 5 years. So make sure you look at the dates on that certificate. It should be posted in a hallway in a common area somewhere. And if it's not, tell the landlord that you're getting the listing from that they need to arrange for that inspection and get it up to date, because any buyer and buyer's agent worth their spit is going to be is going to check that, and they're going to want to make sure that it's up to date. Otherwise, you're going to have a buyer that's buying into a building that's going to immediately then need to get this inspection done. But if they're buying and they have a lender, the lender is going to want to make sure that's up to date too, because there's not going to be a local city inspection that gets done. They're going to want to see when the expiration of that current inspection is coming about. So landlords must maintain temperatures. We already seen that in the screenshot. I didn't require you to highlight it or anything. I just had a little asterisk next to it for your own edification. And when a landlord does not when a tenant's not paying the rent, landlords still cannot turn off the heat or hot water or shut down any services, change the locks or anything like that. They have to evict the tenant. They can't shut off their services to try to force them out. Typically, leases restrict a tenant from subleasing. You know that ours do. We have that clause in our lease. I'm showing you this lease again. That talks about subletting or subleasing. Where was it? Says something about no subleasing, subletting allowed. What was that? No, I'm passing it somewhere. Oh, here we go. No assignment or subleasing allowed, right? So we got a section in our leases pertaining to that. You could always ask the landlord still, even though we have it in the lease, and the landlord could permit it if they wanted to, if they're willing to. Hey, contracts could be, landlords could always change their mind, even though it's in a lease, You could maybe even ask them to novate the contract so you're relieved of any obligation if you get another tenant to take over. Even though our leases specifically say that they can't. Notice to quit requirement would vary depending on the type of leasehold estate, right? State for years, no notice is needed. You got to be out if you're not signing a new lease. Tenancy at will, 3 months notice. Periodic estates, depends on the term of the lease. Year to year, 3 months notice. Month to month, 1 month's notice. Week to week, 1 week's notice. That's on page 241. Just put a highlighted box around that there and turn the page. Everybody got that?
Yes.
Yes, got it.
So that truth in renting booklet, we know that we got to give it to tenants in buildings with 3 or more units. Here's a link to the DCA's website and a link directly to the truth in renting booklet in English. If you go into their website, you could also get access to it in Spanish. I believe they have it available there. They got it available there in Spanish as well. Oh my God, I keep passing over it. So let me get to that slide so that I could copy these links and share it with you. And there's also a flood risk notification, which we'll see on the next slide. So the Truth in Renting booklet, beginning March 20th, 2024, every landlord must provide notice to prospective renters about the FEMA's new flood hazard area and moderate flood hazard area. Acknowledge that the rental premises or any portion of the rental premises, such as tenant parking spaces, may have been subjected to flooding before in the past. So here is the DCA's website, the Truth in Renting booklet, and that notice for flood risks that we now need to give. So I'm going to share that with you in the chat window, all 3 of those. The basic DCA's website, and that's where you could also get that Truth in Renting booklet. Okay, so here's the DCA, Department of Community Affairs website. Here's that access to that notice for the flooding. Here, flood disclosure and notice, related forms and publications, and laws, rules, and regulations. So here's the flood risk notice. where the landlord has to provide this to the tenant, that if the property's in a 100-year or 500-year flood zone, and if they had a history of any flooding there before. And go back to this. So if you're a landlord right now, if you're not doing that yet, you have to do that now, okay? Let's see, here is basically the Truth in Renting booklet in interactive form, just by the titles and sections that you could go to. But if you scroll down somewhere far enough, here we go, the Truth in Renting booklets, the guide, it's in English and Spanish right here. So the Truth in Renting Act, that's the law. The Truth in Renting Notice, it's in English and Spanish. With the here's just a notice that shows you it's available in English or Spanish. That's kind of stupid. You got it right here. You could just click on that. Here's pertaining to the law. When that law was passed in 2008. Here's about security deposits, the bulletin and the law. You got questions about security deposits and how that works? Looks like this was passed in 2003. So all the information you want, here's that senior citizens 5-day grace law. It's basically for anybody, not just seniors, but anybody collecting a rent from the, getting their rent money from the government. Did you know if the property gets foreclosed on, when the bank forecloses, they cannot kick you out if you're a tenant? The bank, the lender, whoever buys the property at auction, they have to honor your lease. That's probably what they're discussing here in these notices. All right. So I'll give you guys all these resources there. So I'm pretty sure they'll probably have this new law on a question about it on exams. FEMA's special flood hazard area, where landlords need to disclose to tenants if a property was ever flooded. All right, page 242. This is who you need to give the Truth in Renting booklet to, right? This is the third paragraph down on the page. This is the third paragraph on the page. Truth in Renting. The Act requires residential landlords of dwellings with 3 units or more than 3 units, if the landlord occupies one of the units, to distribute the Truth in Renting statement to each of their tenants at or prior to the tenant's occupancy. I just wrote in my book here that it's required to be given to tenants in buildings with 3 or more units, not counting the unit the landlord lives in. Or you could just do this, do a whiteout over here. The act requires residential landlords of dwellings with 3 units or more than 3 units if the landlord occupies one. There you go. So you don't have to write that much in there. Because the book says more than 2 units or more than 3 if the landlord occupies one.
Got it.
All right.
I'm good.
1 second.
Got it.
You need to disclose disclosure of owners and managers to the tenants and the municipality for emergency purposes. The names and addresses of the owner or resident managers must be on file with local government and state agencies when they register their property for rental use. And we need to notify the tenants in high crime areas that federal crime insurance from the Department of Housing and Urban Development is available in high-risk areas. By the way, let me put out there the attendance poll after lunch. Come on, 2 more people answer. Attendance poll, please. 1 more. The Americans with Disabilities Act. This is something we went over in chapter 4 as well. But now that we're in the leasing chapter, we'll discuss this because. All right, so the ADA, that's the Americans with Disabilities Act. This was a law that was passed to prevent discrimination against people with disabilities in the workplace. Now, Title III of the ADA prohibits discrimination in commercial buildings, requiring them to be handicap accessible. It says that all new construction must be handicap accessible. For existing structures, the ADA recommends reasonably achievable accommodations to provide full and equal access to facilities and services. Reasonably achievable accommodations means at little cost without massive retrofitting or remodeling. Now, it may be useful to consult with ADA experts and architectural designers as well. What kind of properties are these for? Is the ADA about?
For handicapped, disabled,
What kind of
people.
property does the ADA cover? The Americans with Disabilities Act.
Residential,
Commercial.
commercial.
Title III of the ADA prohibits discrimination in commercial buildings. Like movie theaters and shopping malls and strip malls, they need to be handicap accessible because the purpose of this law was to prevent discrimination in the workplace. But that also is for customers and other people who may have disabilities so that they could have equal access to these facilities and services too. Now, some examples of reasonably achievable accommodations would be things like lowering wall-mounted payphones, if you could still find them, lowering water fountains or installing a cup dispenser as a workaround instead of lowering the water fountain. Just make sure you don't run out of cups then, because some ambulance chasing attorney looking for lawsuits will be there. Changing the direction which doors open or adding ramping, changing door handles to push bars, installing auditory signals or braille buttons to elevators, making handicap parking spaces available for people with disabilities where appropriate as well. So here's where we do the highlights for the ADA in the book. Americans with Disabilities Act, Title III of the ADA prohibits discrimination in, I underlined it too, commercial properties. And then to protect the owners of existing structures. See, it's easier to make, if you're constructing a new building, it's easy to make it handicap accessible. But trying to retrofit and modify an older building, that could require massive construction in order to try to remodel it. So the ADA's recommendation is reasonably achievable accommodations with to provide the access to those facilities and services to those with handicaps, with disabilities. So you need to know for exams, what is the ADA's recommendation when it comes to existing structures? Reasonably achievable accommodations to provide access to facilities and services. What kind of properties does the ADA
Commercial.
deal with? Commercial. What is the purpose of the ADA? The Americans with Disabilities Act. It's to make sure that they have full access to the facilities and services. Let me know as you get those highlights down, please. I want to try to finish this chapter. We got a half hour left. I want to finish this chapter before we go.
Got it.
Pertaining to service animals, which we went over in chapter 4, just highlight the title service animals, and only 2 questions may be asked of people. Is the animal required because of a disability? And what work or task has the animal been trained to perform? At least in places of businesses pertaining to the ADA. Now, in residential residential housing, the landlord has to allow both the service animals that are trained to perform tasks, but also the emotional support animals. If the tenant has a letter from their doctor or therapist certifying on their letterhead, certifying that they have a medical need for one. Here's just some more examples of the ADA, what a reasonable accommodation is. Allowing people to have those service animals like a guide dog, or in some cases, a miniature horse, provided that your structure can handle it and has a room. Now, rental referral agencies, we went over these actually in chapter 1. It was the last thing in chapter 1. A rental referral agency is when you get those contracts with property owners of apartment complexes who usually have their own rental offices, but you enter into a contract with them that where they agree to pay a referral fee if you find renters for their units. But to make sure that you are not advertising a property that's no longer available, rental referral agencies, they need to check with the owner to see if one of those units are still available. If it's for the different types of models of rentals, you know, studios, 1 bedroom, 2 bedrooms, and different styles of them. If you advertise it, you need to check every day with them to make sure that one of those units are still available. If it's an in-house only listing that's not advertised, we need to check if a unit is available every 3 days. And any advance fees of more than $25 that we collect from those would-be tenants, we must put them in an escrow account. So, highlight, if a prospective tenant is charged an advance fee of more than $25, regulations require depositing those funds into an escrow account. That's on page 244. And on that same page 244, you're also going to underline, or you could highlight these things too. Let me also bring a highlight to that. See, the thing is, they say units that are simply listed in the MLS must be checked every 3 days. But the thing is, there's no such thing as simply listed in the MLS, because often those units that are put in the MLS are added, are syndicated out to third-party websites too. So it's going off to other places to get advertised. So there's no such thing really as simply listed, unless it's an in-house listing. So people who walk through your front door looking for a rental, you got them in your database as a rental property. That's a little bit different. All right, rent control, we already spoke about this a little bit, but rent control laws are set by each municipality, and not all municipalities have them. These laws are put into place to prevent abusive landlords from taking advantage of tenants. Rent controls, raising the rents, charging late fees, how evictions occur, etc. Licensees should be careful when showing rental properties for sale to investors. They should use caution before telling them that rents are below market rates and they can always be raised. Got to be careful. If the municipality does have rent control, they may not be able to raise them. And now, if that investor bought that property based on the advice that you gave them, now they could turn around and try to sue you. So on page 244, right next to rent control, rules are set by each municipality if they have them. And then put an asterisk next to next to it on page 245 at the top of the page. I believe that's at the top of the page. Yep. It says, although rent control clearly benefits tenants, many argue that in the long run it can hurt them because it could discourage investors from putting up rental housing and can cause hardship to landlords who cannot bring rents up to fair market values, encouraging them to let buildings deteriorate and even eventually become abandoned. So basically those older buildings, they basically turn them into slums. Because if the landlord can't keep up with raising with the costs of living, the cost to maintain those buildings, this is not a hobby for landlords. It's a source of income. And if it's a matter of, do I feed my family or do I do improvements to a building to try to maintain it and dump all my money into that, which one do you think they're going to do? Look out for their own family, right? So this is why in older buildings that they institute rent control laws in those municipalities. Some landlords could start letting their buildings go and not keep up on the repairs because now it just becomes a money pit to them and it's no longer income producing asset that is beneficial to their family. So they're just trying to get as much out of it as they can. And then eventually they'll dump it on some new first-time investor who doesn't know any better, who their real estate agent doesn't know any better either, and is telling them, oh, wow, these rents are low, and the price is low on this property. Hey, you could always raise the rents. You may not be able to, so be careful. So rent control, that could limit how much you could raise the rents, how much you could charge in security. Well, security deposits are set by law throughout the state, but how much you could raise the security deposits by, when you could evict a tenant and things of that nature, raising the rents, okay? So condo conversions, these are buildings, older buildings that are apartments or multi-unit houses that could be converted to condominiums. We went over this in chapter 7, I think. So who cannot be evicted during a condominium conversion? Well, those age 62 or older, or certain disabled persons. They had to live there for at least 2 years before the conversion began. And if their income is no more than 3 times their county's per capita, or in any case, no more than $50,000 per year, they could remain as tenants for 40 years. You can't evict them just because you want to convert it to condos that you're going to sell the units. So let's highlight that in the book and write condo conversion evictions next to it. I know we highlighted it like in chapter 3. We highlighted it again in maybe chapter 4. Well, we're highlighting again here in chapter 12. This is where it says eviction, not where it says constructive eviction, but where it says eviction. It's the second paragraph. You're highlighting that and then just writing condo conversion eviction. Let me know when you have it.
Got it.
Okay.
Got it.
Constructive eviction just sounds like construction, right? Well, that's exactly what it is. When there's a problem with the construction or there's a condition that could endanger the health or safety of those who are living there. If the landlord fails to make necessary repairs, the tenant can legally terminate the lease early due to constructive eviction. So this is an action taken by the tenant to legally terminating their lease early. If the landlord fails to provide basic services or make essential repairs when there's an uninhabitable condition, the tenant must notify the landlord there's a problem. And if they don't fix it, then they have to vacate and move out and then stop paying rent. The tenant would notify the landlord they're terminating the lease early due to constructive eviction. You should seek legal assistance with this before taking any action, though, to make sure you're doing it the right way. Landlords must return all security deposits in that case. We know there's damages because that's why the tenant is moving out. So here's an example of a real case of this that I had one time where I had the landlord as a listing. He had a basement unit apartment in a single family house that was grandfathered as a two-family for rental purposes. The basement he was allowed to rent out separately because it had a separate entrance from the outside, this door that went directly down. Now, he was the tenant that I found him. Yeah, I got both ends of the deal. I found him the renter, the tenant. She was a brand new single mother of a newborn baby. The landlord, he just slapped a coat of paint on everything, made everything look nice. But after she's been living there for a couple of months, she gives me a call. Victor, what do I do? I said, what's the problem? Well, the landlord, he doesn't like to talk on the phone, but he's usually very good with communication by text message or email. I said, okay, well, what's the problem? Well, the people upstairs, every time they flush the toilet, it comes out in my tub. I noticed this when I was first bathing my baby. She was bathing her baby in one of those, those plastic tubs that you put inside the tub, or sink. So she had one of those and she was bathing her baby in the tub, and then they flushed the toilet upstairs and it started coming out into her tub. Oh, it's disgusting. Or imagine even if you're taking a shower and they flush the toilet upstairs and it comes out in your tub. That's disgusting, right? I would say that classifies as an uninhabitable condition. What about you?
Yes.
Yeah.
Horrible.
So what happened here? Well, the sewer pipe, before it got to the street, the sewer pipe that's still on his property, it collapsed because of roots or whatever the hell it is, age. It collapsed. So every time they flush the toilet upstairs, it comes down, it hits that collapse, and then it backs up to the lowest point, which is the tub in the basement. And then it slowly drains out. And the landlord knew that now that there's this problem, he knew it's an expensive repair. He didn't want to do it right away. He's trying to milk it as long as he can, get away with it. I guess he didn't believe it was that bad. I don't know. So she's like, what do I do? He's not answering my calls. He's not fixing it. I don't know what to do. I can't live like this. This is disgusting. I said, I don't blame you. I said, you got anybody you could temporarily move in with until we find you another place? She said, yeah, I got a girlfriend I can move in with. I was like, okay, well then how about you do this? Can you document your communications with your landlord, trying to get in touch with him? She said, yeah. I got all the text messages. I got all the emails. I was like, okay. I said, this is what you should do. And I said, I'm going to give you some advice here, but this is legal advice, and I'm not a lawyer. So before you do anything, I don't want you to get you in trouble. Make sure you talk to an attorney. I'm going to give you an attorney's number. You call him. Just verify with him that I told you to do things the right way, because I don't want you to get in trouble, because I'm not a lawyer, and I don't want to give you bad advice and get you in trouble. So make sure you don't do anything until you talk to the attorney first, okay? But he won't charge you for it. I know him. So I gave her a number, and so she called up the attorney. He told her, yeah, I gave her the right advice, which was, notify the landlord again that you're, that you got this problem, and Then go down to the city, because this was in Edison. I said, make sure you go down to the city. In Edison, the rentals are handled by the health department. So go down and file a complaint with the health department about him. And then move out. After you got your stuff all out, and only after you got everything out, notify the landlord you want to terminate the lease early due to constructive eviction, and you want all your security deposit back. And then he has to give it to you. This is a legal way that you could terminate the lease early because of the landlord's failure to make the necessary repairs. And she did that. And when she said, she called me up, she said, you know, when I went down to City Hall, apparently they know about this guy. They're like, he owns a bunch of rental properties apparently, and he refuses to do any work other than slapping paint on stuff to make it look nice. And then when there's a problem, he refuses to make repairs until they force him to. They knew the guy by first name. I was like, oh, okay. So yeah, that was the issue she went through. So that's constructive eviction. Now, sometimes constructive eviction is intentionally done by landlords to try to illegally get tenants out by having something broken and purposefully not fixing it because they want the tenant out so they can get someone else in there that'll pay a higher rent. That's illegal too. Now, suit for possession or actual eviction, that's different than constructive eviction. This is actual eviction is an action taken by the landlord. Eviction is the process of the court revoking the tenant's rights if a tenant breaches the terms of the lease. The landlord files what's known as a summary or dispossess proceeding to dispossess the tenant from the property. And a landlord must provide a notice to quit first to the tenant before they could file for eviction, except if it is for the reason of non-payment of rent, and then no notice to quit needs to be provided first before they could terminate that lease and start the eviction. So how much notice is needed to provide a tenant with a notice to quit depends on what the reason is. There is a guide on page 245 and 246, which is going to be on the next slide. But if it's for non-payment of rent, no notice is needed. They could just immediately go and file for the eviction if the tenant's not paying the rent. Any other reason, the landlord has to first send a letter to the tenant, serve them with this document stating you're in violation of the lease for whatever reason, and they're going to come back and check on you and see if you're still violating it. Then you may be subject to eviction. So let's make these highlights on page 245. Under constructive eviction, I wrote next to the title, it's an action taken by the tenant to terminate the lease early. It won't be considered breach of contract. So it's a legal way for a tenant to terminate the lease early when there's an uninhabitable condition. Action by the tenant to legally terminate the lease early due to an uninhabitable condition. So that's when the landlord fails to make those necessary repairs. It's an action taken by the tenant to legally terminate the lease early due to an uninhabitable condition the landlord doesn't fix. They don't repair. It could be failure to provide heat or electric or water, or the sewer pipe is backing up and they don't fix it. Everybody got these things highlighted?
Got it.
Anybody else need more time?
I'm good.
1 second. Oh,
Okay.
early. Done.
All right, so at the bottom of this page, it says causes for eviction. That's the, I told you that the landlord needs to serve proper notice for any cause for eviction other than non-payment of rent. You need to know that for exam. The non-payment of rent is the only time that the landlord can start eviction without providing a notice to quit to the tenant, or serving proper notice to the tenant. That's how they may refer to it as. So here is that guide, which starts on the bottom of page 245 and continues on to the next page, 246. Here I got a screenshot of it from an older version of the book because it all fit on one page. But right at the top where it says causes for eviction, I wrote landlord's guide for giving tenant notice to quit before they could file for eviction. I know it's kind of wordy, but it's a call it whatever you want, okay? But that's what I call it because that's what it is. You don't need to study this guide for exam or anything. But if you're a landlord, or if you're going to be dealing with landlord and tenants, this would be a useful guide for you. That's the only reason why I'm telling you to name it and then put a highlighted box around it. But I will tell you to highlight this part that says non-payment of rent, no notice to quit need not be given before the suit is filed for eviction. That's the only case for non-payment of rent. And then in this class, sometimes I tell you guys about movies and TV shows that deal with some of the issues that we come across. And here's one of them. Anybody ever see that show called World's Worst Tenants? It's no longer on the air. It used to be on a channel called Spike TV. It was like a guy's channel, like a guy's channel, you know. And it had all kinds of shows. This show, you could find it archived online, and you could watch these on YouTube and other places. But you could find it online. It was called World's Worst Tenants. It was basically a recreation of actual situations where these people who were landlord tenant eviction specialists, or whatever they called themselves, something along that line, where they would do the communications with the tenant on behalf of the landlord, like when they needed to serve a notice to quit so the landlord didn't have to deal with tenants directly. And one of these guys, he's like a former Marine, he's all jacked up, and then there's his wife, who was an ex-cop, and then his buddy, and it was these three people, and it showed you a history of real stories that they've come across, and these are the real people that dealt with these issues. But it's all recreations of these issues that they came across when dealing with tenants on behalf of landlords. And some of them are really wild. So I just got that link here. It's also in the class links Word document that you could find in that shared Google Drive, once again. But here is the link to it. I'll share it with you. You guys can watch it online or on your computers or TV or whatever. It's called The World's Worst Tenants. And there's a link to it where you guys can watch those episodes. You can watch them all online or in your smart TV.
Thanks, Victor. I'd actually like to watch that. I'm curious.
Yeah, it's pretty interesting. They had this one where they had a tenant that usually paid on time, and he was late in his rent, and they were worried about him because they're like, this guy's never late on rent. So they tried calling him and such, and he's not answering, not picking up. So they send out their crew to go out and check up on him, and uh, he's he's kind of a big fat dude. And when they went and knocked on the door, they're like, "Do you hear that?" They could barely hear somebody, and they thought that somebody was calling for help. So they broke down the front door and they went in. The guy apparently, and this is a true story, he was taking a shower and he fell down in the tub. And because he was so large, they had trouble getting him out too because he was like stuck in there by suction and they couldn't get him out of the tub. But apparently he was there for like a week. They ended up calling emergency services to come get him and get him out, and but it was a matter of safety. This guy normally pays on time, but it was an accident, a medical emergency. He got stuck in the tub. That's why he was late. Good thing they didn't wait longer. Just this week, because I was running for councilman in my town. I didn't win it, I was pretty close to it, but they threw in a third party person to siphon off some of the votes for me, so I didn't win it. So people still reach out to me though about stuff. And the other day, in my town, in my section of town, they were asking. Somebody sent me a picture, and they were like, "Hey, what's going on over here? We see an ambulance was there." And today, it's all wrapped up in police tape and there's cop cars all over. What's going on? They sent me a picture with all the police tape. And I was like, well, that's a crime scene. I'll tell you right now, that's a crime scene. They're like, well, there was an ambulance there that took the old guy away earlier, you know. And so I looked into it and I ended up finding out, it's still under investigation and all, but apparently the old man that was living there killed himself, but the police wouldn't tell anybody because it's still an active investigation. It's going on. I was just able to find that out. So, I shared that with the concerned neighbors over there. It looks like he killed himself, but they're not sure. That's why they're doing an investigation. But this is the kind of stuff that you would see like on World's Worst Tenants. There are some really wacky ones dealing with the real estate agents that were doing something that they shouldn't do. You had squatters. There's many instances of squatters. There's people who had exotic animals they shouldn't have had. There's all kinds of shows. Yeah, watch that show. You'll get a kick out of it. Tell me next week if you watched any of them. I bet you'll get a kick out of some of them. These are one of those viral things that'll waste your whole day watching them. It's kind of like a train wreck. You can't look away, right? All right. Let's go over leases, payments, and what's included. We're nearing the end of the chapter here. Let's get it done. Oh my God, we're already at the end of our time. So let's kill this. Let's finish this off here. Types of leases. Right next to it, payment and what's included. Kind of like the types of leasehold estates, but this is actually talking about the types of leases. Next to where it says a net lease, I want you to write NNN. That's known as triple net. There's a net lease, but there's also something called triple net. So write NNN next to that. And where it says the obligations of the lessee, that's the tenant, and the obligations of the landlord, the lessor. The landlord for the net lease may pay some property charges.
Why triple net?
Actually, that's pays basic rent plus all or most of the property charges. Wait, hold on a second. This actually goes over here. Except mortgage financing. I'm sorry, what was the question?
Why it is called triple net? Is there any reason?
Yes.
Or just
Yeah, I'll give you that reason in just a moment. I just want to get through everybody getting this down first, and then I will explain that to you. Oh, well. Well, this is, except mortgage financing should be on the tenant's side here, the lessee. Just noticed I was on the wrong side. Okay, everybody got that?
Yes.
All right. So here are the different types of leases. You have a gross lease, which is a typical lease that people pay on residential leases. It's common in residential. You may be able to find it in commercial, though. It's where a tenant pays their fixed rent and the landlord's responsible for all the property taxes, insurance, mortgage payments, and any repairs that the property needs. That's a gross lease. Everything's included. Gross. It's the gross. The net lease is common in commercial properties, commercial and industrial property, where the tenant pays rent and some or all of the property charges. Now, when the tenant's responsible for paying all of the property charges, it's known as a triple net lease. Here, let's actually word it that way. Let me reword this a little bit. The tenant pays rent and some of the property charges, whatever was agreed to in the lease. So that's what a net lease is. But in a triple net lease, where it says NNN, that's triple net, the tenant pays rent, they're responsible for paying the rent and all other property expenses except for the debt services like a mortgage loan. The tenant even has to pay the property taxes. And they pay something that's called CAM charges. CAM is common area maintenance charge. So each tenant has to pay their share of the fees of the proportionate to the percentage of the area that they're renting. Like if you're renting the whole building, you're responsible for the entire CAM and property tax charges. My school is only in 5% of the total building space. There are other tenants there. So I'm only responsible for 5% of the property taxes, 5% of the landscaping fees, 5% of all of that. Okay. The landlord's insurance on the building. Okay. So that's why it's triple net. You're not just paying some of the charges, you're paying all of them. That's triple net. You pay all other expenses. So let's highlight gross lease, the tenant's obligations to pay a fixed rent, landlord pays all other insurance, mortgage payments, etc., and it's most often used in residential rentals. Get that down, let me know. I'll switch the slide and then I'll give you the next thing to highlight so that we can get through this because we're right near the end. Let's just finish this chapter.
Done.
Okay. Everybody good?
Yeah.
Yes.
All right. Now on 247, highlight this and make these notes. Next to net lease, you could also write triple net NNN, common for commercial and industrial. In addition to rent, the tenant pays some or all of the property charges. With a triple net lease, the tenant pays taxes, insurance, and all other expenses and except for debt services. Debt services are the mortgage loan.
Done.
Okay.
I need a second.
Anybody still writing or?
Yes.
Okay, I'll give you a sec. Just let me know when you're done.
No, thank you.
Okay. In a percentage lease, well, we'll get to that coming up. I think I'll have a slide on that. So how do you calculate rent on a triple net lease? Well, if the rent is $20 per square foot and CAM charges are estimated at $5 a square foot, do not just add them up and then multiply them by the square footage, because then you don't get an idea of what your actual rent is. Those and CAM charges can vary, and the tenant has to pay whatever the actual CAM charges are. You don't go by an estimate, but except you ask for an estimate before you move in though. So if it's $2,000 a square foot and the rent is $20 a square foot, it's 2,000 times 20. That's $40,000. That's not monthly though. That's annually. So you're going to be paying $40,000 a year in rent. So you divide that by 12 months, and then the monthly rent is $3,333.33. That's the rent. And the estimate of the CAM works out to about $833.33 a month rent. Add them up, and the total rent with rent and CAM charges could average out about $4,166.66. And now you could determine, hey, is this too rich for my blood? Is this too expensive? Do I need to find a cheaper place to open my business and run it? Or can I afford this? Okay. That's how you shop around for commercial properties and try to determine a value based on price per square foot. So the percentage lease is common in large shopping centers. The tenant pays a small fixed rent plus a percentage of the gross income. A percentage of their gross income in total, or perhaps above a certain figure. The landlord could add a provision that the tenant must gross a certain minimum amount in sales and as well. So the rent may vary according to the nature of the business and the rental agreement. So basically, the tenant pays a small fixed rent plus a percentage of whatever their gross sales of their products are. You ever see a small shop like in Woodbridge or Menlo Mall, and it seems like they're doing killer business, and then next thing you know, they're gone. They're out of business. They disappeared. You guys ever see that store that was there and it was doing great business? Then all of a sudden, they seem to be always busy, but then they're gone.
Yeah.
Well, that's probably because they had a percentage lease, but they also had to pay a percentage of the gross income to the landlord. And then the landlord had a further agreement that they needed to net at least a certain amount. They had to gross at least a certain amount, and they may not have been getting that amount based from all the widgets that they sold. Okay. Their widgets, they may have been really busy selling their widgets. That's an imaginary product. But they didn't, the widgets were not getting them enough money to satisfy the landlord's ferocious appetite. So that's why they closed down. Okay, they were still asking for too much rent, basically. Now, there are other provisions where it says other lease types. They're talking about provisions added to longer term leases. Like if it's a long-term lease, you could have built-in rent escalations into the lease that are predefined, or sometimes it could be attached to the cost of living index in a newspaper, like the business section of the New York Times on the anniversary of the second Sunday of whatever month, as published in the New York Times. Whatever that cost of living index is, if it goes up, that's how much your rent goes up by. Okay, that could be another way that they do variable leases. A ground lease is a type of triple net lease where the tenant rents raw land and then they construct a building on that land. So therefore, they're responsible for maintaining that building and the land, as well as the increased taxes now that need to be paid on that land. Okay. Some examples of famous ground leases are in New York City, you have the Empire State Building, the MetLife Building, the Chrysler Building, those World Trade Centers when they were up there. The land is owned by the Port Authority of New York. Do not confuse ground leases with land contract, which is a type of seller financing. Sometimes people confuse the two because, you know, ground lease is a lease of the land that you then erect a building on. A land contract is a type of seller financing to buy that land. And then a mineral lease or oil lease, gas lease. Landlords rent the land to the tenant who then tries to extract minerals from the ground. And the landlord collects the rent plus a share of the profits from whatever it is, the mineral that they're extracting from the ground, whether it's oil, gas, gold, silver, or any other kind of precious mineral. You see shows on TV like Alaskan Gold Rush. Anybody ever see that? Where you got those guys that are trying to dig and find where the gold is and then run it through the sleuth boxes and all that stuff, moving tons of soil to get a little bit of gold out of it. And then they got to split that gold with the landlord. So basically, they're paying the landlord for a property that they don't own to dig on their property that they know there's gold on to try to find that gold, get it out of the ground. But these guys usually get very nervous if the landlord says he's going to stop by the operation because they have an agreement that not only do they need to split the profits, but they need to get a certain amount of gold out of ground. Are they on target? Because if they're not, the landlord will end their lease and then get somebody else on that property who knows how to get the gold out of the ground. So let's make these notes. Next to variable lease, just write provisions added to long-term leases. Ground lease is also a triple net lease. When a landlord leases their land to a tenant who agrees to erect a building on it, the lease is called a ground lease. And next to oil and gas leases, just write mineral lease because it's also referred to as a mineral lease. I know I'm keeping you late on a Friday. I know. We're almost there. We're almost there. Just hang there with me for a moment. Now, with these ground leases, it's not uncommon for leases to be 50 years to 1,000 years long. Yeah, I know. Who lives that long? Well, maybe a corporation, maybe a hedge fund. You know, they buy properties like the Empire State Building.
Done.
Okay,
Done.
everybody good?
I got it. Yep, I'm
Yeah.
good.
Yeah.
Okay. So just imagine that. Look at that building for a second. Imagine constructing this building, but you don't own the land that it's built on. You better be getting a long enough lease for that juice to be worth the squeeze for you to put that much money that you invest in it, right? You better get a long enough lease for it to pay back, right? So that's an example of a ground lease right here, the Empire State Building. Those who constructed that building didn't even own the land that it's sitting on. They did a long-term ground lease with the Port Authority. All right, so what is the primary function of a property manager? It's to maintain or increase the value of the property while generating income as an agent for the owner. They may be responsible for securing suitable tenants, collecting rents, caring for the property, budgeting and controlling operating expenses, hiring and supervising employees, or maybe even hiring independent contractors to do work as it's needed. If either way, the property owner will be bound to the contracts to pay these people. Whether if they hire employees, they would become employees of the property owner, not the property management company. Keep proper accounts and make periodic reports back to the owner how their property is doing. So, highlight here on page 248 under functions of the property manager. The property manager is someone who preserves or increases, pencil that in there, or increases the value of an investment property while generating income as an agent for that owner. So what do we call property managers who can legally bind their clients to the contracts depending on the authority that was granted to them in their contract, called the property management agreement, which acts as their power of attorney that gives them the authority to legally bind their clients to the contract. How do those property managers work? What kind of agents are they?
General agents.
Yes, general agents. Very good. Most other agents work as special agents who cannot legally bind their clients to a contract, but property managers are general agents which can, depending on the scope of their authority, which was granted to them in their property management agreement. So that property management agreement, therefore, is their limited power of attorney. We went over that in chapter 3. Everybody got this?
Yes.
Yes.
And so basically, this slide just explains the difference between special agents and general agents. All agents need to abide by their fiduciary duties to their clients: code, care, obedience, accounting, loyalty, and disclosure, if you recall.
Yes.
Yes.
All right, so highlight: a property manager is usually considered a general agent, whereas most real estate brokers function as special agents. That's under the management agreement.
Got it.
All right.
Got it.
The property managers could be entrusted to budgeting expenses, renting the property, maintaining or improving the property so that they could get higher rents. They could be tasked with maybe consulting with an insurance agent, an insurance expert who can evaluate the type of insurance that they have to make sure they have the proper coverages that are needed and make sure they don't have too many coverages that they don't need. If you want to learn more about property management, you could get a CPM. This is one of the property management designation courses that you could learn about, the CPM, to become a certified property manager. Got a bunch of resources here for you about property management. They're also in the class links Word document. Why is that one not looking like a link? Let's do this. There we go. Now it does. And so that's called the CPM, Certified Property Manager. And that's the end of this chapter. Let's do the key terms to review. There's 2 of them. Key terms 1, landlord's responsibility for decent conditions. What do we call that? The landlord's responsibility.
Implied warranty.
Yes. 9 is A, implied warranty of habitability. Transfer of property by lease is known as demise. 4 is B. Situation when a tenant remains after their lease period has expired. What do we call?
Holdover tenancy.
Yep. 8 is C. A contract between the landlord and a tenant transferring the right to use real property for a specific period of time in exchange for rent.
Lease.
10 is D. Lease. A lease for a definite period of time.
Estate for years.
Yes. 5 is E. Estate for years. A suit for possession, legal removal of a tenant.
Eviction. Actual eviction.
Actually,
That's
big.
known as actual eviction. 1 is F. Rental of land in which a tenant erects their own building.
Ground lease. Ground
Yes.
lease. Yes.
Ground lease. 7 is G. Another word for the tenant.
Lessee.
Let's see.
11 is H. Correct. A lease under which the landlord pays taxes, insurance, and other expenses.
Gross
Gross
lease.
lease.
6 is I. Gross lease. Transfer of primary responsibility for a lease to another party.
Assignment.
Assignment.
Assignment. 2 is J. And most of our leases actually prohibit that, but you could always ask the landlord to accept that. The tenant is forced, so 2 is J. A tenant is forced to move because the rental unit becomes uninhabitable.
Constructive eviction.
Eviction.
Yes, 3 is K, constructive eviction. All right. Next, the letter B in key terms 2 at the end of the line. Write and not paying rent. Try to squeeze that in there. And not paying rent. I did it on 2 lines. And not paying rent. Right after letter B. And then after letter D, write automatically renews. Everybody got that?
Yep, I got it.
Okay. So a lease in which the tenant pays expenses like property taxes, insurance, and so forth.
Net lease.
3 is A, net lease. Tenants remaining after a lease term without the landlord's consent and not paying rent.
Tenancy at sufferance.
9 is B, that's a tenancy at sufferance, correct. A lease in which a landlord shares in the gross receipts of the tenant's business.
Percentage lease.
Correct. 4 is C. A lease with regular payments and no stated ending date.
Periodic.
Periodic lease, periodic estate, correct. 5 is D. a person who looks after another's rental real estate.
Property manager.
6 is E, property manager. Tenancy that may be terminated when the landlord wishes.
Tenancy at will.
Yes. 10 is F, tenancy at will. Landlord's court action to evict the tenant.
Sue for possession.
Suit for possession. 8 is G. A transfer of only a portion of a lease.
Sublease.
Sublease, correct. 7 is H. 7 is H. Property manager's employment agreement. What do we call that?
Management agreement.
Yes, 2 is I, management agreement. State requirement that tenants be notified of their rights.
Truth in renting.
Yes, 11 is J. And another word for landlord. What do we call the landlord?
Lessor.
The lessor. 1 is K. All right, that concludes chapter 12.